let's talk about Bill C-48 with David Lametti, Canada's Minister of Justice and Attorney General. Minister, good to have you here.
Pleasure to be here.
Now, C-48 comes 4 years after Bill C-75. That was another set of major reforms your government made to the bail system. Is this new bill an admission from your government that those previous reforms have gone too far?
Not at all. In fact, we haven't changed anything in C-75. We have just added a number of provisions targeting repeat violent offenders, targeting certain offenses with guns, knives, bear spray, weapons, because the provinces had identified this as a problem. Way back in October, first identified at a federal provincial territorial ministers meeting by British Columbia. Other provinces also weighed in. So we began the work at that point at the technical level. We had the tragedy with Constable Pershala in December. January, the premiers wrote a letter to the Prime Minister outlining their concern, and we scheduled a Justice Ministers meeting in March. This is what came out of that meeting.
So then does this boil down to you then essentially responding to that push from provinces, responding to the criticism they've even leveled for months, and including what we've heard today, even from the Conservatives on Parliament Hill?
Well, look, I don't accept the criticism of Bill C-75. I think that the changes that were brought to the bail system were very good. They basically enshrined a number of Canadian Supreme Court decisions, and I think made the system better. But I was listening to the specific kinds of concerns that provinces and territories had, and of course we acted in good faith to try to improve that. That's what we've done today. There's been a lot of back and forth between the provinces, territories, and us since last October, and since that Justice Ministers meeting in March. So we've done a lot of work. We've done a lot of work with stakeholders, the police associations. They came out in support of what we did today. As well as British Columbia and Ontario already, and we just tabled it. So it really is the product of a lot of collaboration and cooperation.
I do want to get your response to what criminal defense lawyers are saying. The president of the Criminal Lawyers Association today calling this bill a huge step backwards from Bill C-75, calling it a knee-jerk reaction to some serious but isolated incidents of non-compliance, also saying that these changes ignore what the Supreme Court has been saying about release and bail conditions. What do you say to that?
Well, I think, first of all, I think very highly of Daniel Brown. He's been an outstanding, I think, advocate for criminal justice reform. And I certainly do take what he says very seriously. I do think we are within the Charter, so I think we're within the standards that have been set by the Supreme Court. These are and what we're doing here is a very targeted set of measures. Again, repeat violent offenders and offenses with weapons, where we're reversing the burden of proof. Again, because of the narrowness of it, I don't think it represents I think the kind of negative step backward that Mr. Brown believes it is. I think it's actually working within the current system that we have, that we set in C-75 and the Supreme Court has set for us.
So following from that, your government has made it a priority to look at the overrepresentation of Indigenous people and Black Canadians in the justice system. How does C-48 match with that priority?
Well, that still is a priority, and we identified that as a priority with the premiers in our unanimous communique last March. We think that because we've narrowly targeted what we're doing, that we won't have a negative impact on the battle against overrepresentation. That's still primordial to me and me as a Justice Minister, but it should also be primordial to Canadians in general.
Okay, so I do want to ask you then about some of the specifics in the bill. You are creating a reverse onus for serious repeat violent offenders involving weapons where the accused is convicted of a similar offense within the past 5 years. So why did you decide on that scope of taking that 5-year time period and making it specifically about offenses with weapons?
Well, again, this is something we heard from the Premier. So what we're trying to do with that provision is attack a pattern of behavior. So again, the repeat violence with the weapon. And so keeping it within 5 years means this person is continuing to do this. And what we're doing then is reversing the onus for that. That person now has to prove, if they do get rearrested, that they ought to be out on bail and that it's not a threat to public safety. The default position is they will be detained until their trial. So again, it's the pattern. It's a fairly tight set it's a tight time frame with a tight set of criteria, and we think that it's not only charter compliant, but meets the concerns that were raised by provincial justice ministers.
Now, another aspect of C-48 deals with judges and the fact that they're going to have to look at an accused person's violent history and the effect of their release on community safety. That's going down on paper in the bill. Now,
right.
It seems like these would be obvious matters that judges would already be considering. So why is there a need then to kind of codify this into law?
Yeah, well, we're codifying a procedure, right? We give judges discretion, and I think that is one of the hallmarks of our system. It's one of the real strengths of our system, the discretion that we give to judges and justices of the peace, in this case for bail. What we're doing is structuring their discretion by asking them to think through a couple of different steps. And a number of them would have done this already. But we have had cases. Again, there was a case of an offender in the Yukon who was supposed to be returned to the Vuntutwichin Nation and Indigenous Nation, and they were afraid. They hadn't been consulted. They felt they should have been consulted. So what we're trying to do is at least ask judges to take into consideration those kinds of concerns. Many of them were already, but in cases where they weren't, we're hoping to structure their discretion so that they will at least ask the questions. We're not telling them how to decide, but we are asking them to think through a certain set of issues.
Okay, I want to finish with you on this because twice in the preamble of this bill, you talk about the need for people to have confidence in the administration of justice. As you mentioned, a lot of this push for bail reform came after the killing of OPP officer Greg Pierschala. There have been a number of other violent incidents making headlines. What is your message to Canadians who perhaps aren't feeling all that confident in their justice system? Well,
I think that fundamentally our justice system is a very good one. I think it, frankly, is the best one in the world. I haven't seen one that's better, and I've been in the law all my life. That being said, we understand that there are fears and there are concerns, and we're trying to address those fears and concerns in a reasoned and rational way. I don't believe you can boil criminal justice down to a slogan. I don't believe you can boil bail reform down to a slogan, as frankly the opposition does. That leads us nowhere. It leaves us empty, quite frankly. So what we're doing, by listening to people, by listening to experts, police officers who've supported this bill, by working with our counterparts in the provinces, by working with other stakeholders, including ones who disagree with us, we are trying to come up with a balanced piece of legislation. I think in that sense they can have a great deal of confidence in the system that where there's a perceived gap, we're fixing it.
Okay, we have to leave it there. Justice Minister David Lametti, I want to thank you for your time tonight.
Thank you.